Megan. So I've been noticing in the news over the last couple of weeks that there's been a lot of public sort of stories on blogs, etc., about this macaque, a type of primate, female, who took a bunch of really cute selfies of herself using a nature photographer's camera back in 2011, and that these pictures sort of surfaced on the internet, sort of representing the endangered species on Wikipedia, and that the photographer is now saying that he has a copyrightable interest in the photo. You being sort of our expert in copyright and IP, I was wondering what your thoughts were.
I thought you were going to say, well, a monkey walks into a bar.
Right.
So those kinds of issues happen, I guess, in jokes and then also in intellectual property. It seems like we always get the strange kinds of issues coming up. When you think about copyright, it traces back to the Constitution. So when we want to know if something is copyrightable, we go right back to the Constitution and look at sort of the language that talks about authors and their writings. I like to think of it as the Constitution says that we have a better country for when people create stuff. And so there are these exclusive rights that we attribute to authors for their writings. And you can imagine over time, there's been a lot of litigation over what's a writing and who or what is an author. So originally writings may mean maps and charts and books, but thinking about the vast creative output we have today, that has extended to music and sound recordings and sculptures and even performance art, choreography under certain situations. So what writings are really is given a very expansive definition. Authors has experienced the same kind of development over time. The original author was a romantic author. Anything I create with my hands is of my soul or my spirit. It's this Wordsworth kind of romantic author. But we've had to kind of amend that over time and expand our notion of who can be an author. So in the early 1900s, there was an interesting case that looked at, kind of the quality of art. Does it have to be high art that people create? And one thing that became clear is that we don't want judges deciding what gets to qualify, right? Who gets to qualify? So this is yet another situation where you're wondering about the personality. Is there a personhood that's required to have a copyrightable work?
Yeah, and it's been very interesting to sort of see. So this photo was originally taken in 2011, and the new interest in it has now been because Wikimedia sort of released the fact that the photographer had asked for a desist and take down notice of this particular photo off of Wikipedia's website, and how the story has sort of evolved from 2011 from an animal rights perspective. It was originally, this group of primates took this photographer's camera and sort of spontaneously took these amazing selfies, better than I have ever managed to do, to now that the photographer orchestrated all of this and knew that the camera would be taken, that the primates would act a certain way. So really he authored these photos, and to me it's somewhat of exploitive of these primates, and ultimately one can say, well, regardless, this photographer has become very well known and has become infamous, if not famous, because of this. And perhaps just doing good and bringing awareness to the endangered status of this particular type of primate is enough. And money and copyrightable interest in this particular photo, maybe we just let it go and sort of have it in the public domain and do good work.
You really raise an interesting point, and you hit sort of front and center one of the questions of authorship that happens with regard to copyright, which is that notion of control. There is a great case involving a photograph of Oscar Wilde. And the Supreme Court looked at, are photographs at all copyrightable? I mean, can you author a photograph when what you're doing is really sort of framing a reality? something that we certainly understand now is that there's a lot of creativity that goes into photography, and that element of control over the subject matter, the timing, the rendition of the subject, the posing, look serious, right. All of that can go into the authorial nature of the photographer. And so when the photographer whose camera the primate borrowed is arguing that he kind of set it up, that's where he's trying to go with that argument.
Right.
An issue of control.
I mean, I think it's really interesting, and ultimately when we have any sort of issue like this that can bring awareness to animal issues, and a really sort of interesting intersection here of could a primate be an author of something, I think is always exciting for the legal community and for law students to get involved and sort of think of the law outside of a law library and the books and law school, and really sort of apply it to the real world.
Absolutely. And you know, works that are authored by potentially non-human beings will become more front and center in coming years, because we have a lot of computer-generated works where perhaps a human wrote software, but aside from that software, the actual software itself is authoring poems or even books in the voice of a certain author. So those kinds of questions, I think, are going to become more and more relevant as time goes on.
Absolutely. Well, I guess we'll just have to spend more time sort of talking about primates and authorship and copyrights going into the future.
Sounds great, Lisa. Thank you so much.
Thanks, Megan.